And again, the allegations that you make as it relates to the referee do appear to be fantastic. So I'm at a loss as to what you're alleging.
Your Honor, I was very weak after threatening like some kind of narcissistic abuse that for so long, and I was afraid to bring things up. And every time I have a trial, they told me not to, and now I was alone, and I think that's the only way that the court can see things clearly.
Okay, so what's the basis for your motion?
As the law says, when there's an exiting case, everything has to be filed on the exiting case. Instead of this case, they just come up with a new case without the court involvement and take over the old case. And when I was suffering financially to taking care of my kid.
Okay.
What you just heard is the judge trying to clarify a basic but crucial point. When multiple cases involving the same family, custody, support, enforcement are filed, the court often consolidates them. Why? To avoid conflicting orders. But notice the disconnect here. The mother insists the consolidation was improper, that it excluded child support, while the judge explains that combining cases is routine and shouldn't harm her rights. This clash highlights how one side sees conspiracy and procedural trickery, while the other sees standard legal housekeeping. The drama here isn't just about the law, it's about whether the system itself can be trusted.
Well, this case was consolidated back on February 5th, 2018. And that's not unusual that if you got, a support case and a different, like in this case, the DC case, the cases were consolidated. That shouldn't impact the case at all because you can still make any corrections that need to be made. So again, I'm still not understanding what you're asking for.
I am asking for your honor because of all 2 years unpaid child support. That's what I wasn't able to come up with money to hire an attorney to presenting me until everything went downhill.
Okay, that still doesn't tell me what's the basis for your motion. You're saying you didn't have money to be able to fight it at that time. That's understandable, but it doesn't tell me why we're here today and what the basis is for enforcement or modification.
Well, they consolidated without the court involvement of February 5, 2018, but does not include the support order. I take the attachment. They cross out with a pen. And because of that, I never received any support, nor I can even dig my stuff. So life is just like a nightmare with 2 young kids, and to still affect the case today.
So are you saying that there is no support order at the current time?
No, Your Honor. That order has been finalized on December 2017, but I does not receive a penny since the day you entered the final order.
We've gone through several evidentiary hearings with the front of the court, and this is a support order that was put in place by front of the court, not by any agreements or anything like that. So this is just the state putting this order in place. The children live with me full time. Ms. Parr only sees the children for an hour a week.
Here comes the turning point. The father states the children live with him full-time, and that the mother only sees them for 1 hour a week, under supervision. This detail drastically shifts the narrative. If true, it explains why she's ordered to pay support instead of receiving it. But think about the tension. A mother claiming financial ruin and a father painting her as a supervised visitor. Which version do you believe? And more importantly, do these arrangements serve the best interest of the children, or are they just weapons in an endless war between parents?
Supervised. So she pays me child support, and that's it. There's nothing other than that.
Ms. Parr, is that your understanding that the support order basically obligates you to pay support? You are the support payer?
In the DC case, yes, Your Honor. But in the DS case, you awarded me full custody of both the minor children until the DC case come out in 2018, and then Mr. Spring just start setting a trap with me, all witnessed by the minor children. I attach all the police report as well. He against me in PPR with false police report. And then that's how the DC case come out with the court, without the court involvement. And also in May 2023, 2018, they told me we have meditation at your courthouse. And I was there, witness with Marco from the safe place. They told me if I did not sign a halfway cut down the child support amount on the DS case, on the DC case, I will never receive a penny. And that time I already took 10,000 personal loan just to buy everything.
Did you catch that? She says she took out a $10,000 personal loan just to provide for her kids. That statement carries weight. It paints her as desperate, overextended, and determined to prove her role as the provider. But here's the twist. Desperation doesn't always translate to legal leverage. The judge repeatedly reminds her that the motion must focus on enforceable legal grounds, not emotional backstory. This is a classic courtroom collision, where raw personal struggle crashes into cold legal procedure. And often, the law doesn't bend to sympathy.
It's for my kids and
okay, ma'am, try to focus on the motion. You file a motion for enforcement and modification of child support. I don't need to get into all that extraneous stuff. I just want to know what's the basis for your motion.
Everyone should obey the court order, Your Honor, and this is the order still alive because they did not conciliate with the DHC case. They only consolidated the custody case. You can see that they cross out with a pen.
Well, in this particular matter, the only thing I could suggest, Ms. Parr, is that you proceed through this matter with the front of the court and see if you can't straighten out, again, the consolidation and the other, because quite frankly, as I look at this matter, as Mr. Spring states, there's an order for requiring you to pay child support, so it wouldn't be appropriate for you to enforce the order because all you have to do is pay the support. There'd be no issue in that regard, and apparently the front of the court has not pursued any action in this matter as well to enforce the order. So I'm really, as I stated, I'm at a loss as to what the situation is in this particular matter. So all I can say is you might want to proceed with the front of the court, as they have obviously involvement in both cases, the DS and the DC case in this particular matter. So the court just doesn't find a basis for the motion at this particular time, so I'm going to deny that.
Now the case pivots. She shifts her strategy, moving from child support to custody. This is where emotions skyrocket. She alleges neglect, sexual and physical abuse, alcohol dependency, and failure to take the kids to counseling. These are nuclear-level accusations in family court, the kind that, if substantiated, could change custody entirely. But timing is everything. The judge has already shown frustration with her unfocused motions. So the question becomes, will the court see this as credible concern, or as another attempt to throw everything at the wall, hoping something sticks?
Motion. Mr. Spring, I'll ask in this matter that you would prepare an order denying the motion, and you can submit, if you submit that within 7 days, you can do it without having a hearing. And if you don't, then you're going to have a hearing to get to the order. Ms. Parr, we'll proceed now with your motion for modification of custody, parenting time, and support.
And the judge makes it brutally clear, repeated motions with recycled allegations won't fly. The legal threshold here is called proper cause or change in circumstance. Without new evidence or major changes since the last ruling, the court can't even consider her request for a custody modification. It's not about dismissing her concerns. It's about following precedent and protecting stability for the children. This ruling stings, but it underscores a vital principle. In family law, the burden is always on the moving parent to prove that circumstances have genuinely changed.
Go ahead.
Well, the kids are basically is in a very, very bad situation right now. So they really need to come home. The court need to look into the deeper how everything went just some kind of upside down. And they need to be a loving home. They need to be cared. They deserve everything. So there's a lot of allegation like sexual abuse, physical abuse. They all are attached with the motion.
Okay.
And also the plaintiff, he is alcoholic, and there's ongoing sustained alcohol abuse to the minor children, and he don't take them to counselor once or ever. So this can affect their mental seriously. It can be like a long time.
Anything else that you want me to consider?
Can they come home, my kid?
Well, I'll ask Mr. Spring, do you have any response to the motion?
I would like this to be rejected. The situation with their mother has not changed, so I don't think that there should be any change in the custody order. Ms. Parr only sees the children for an hour a week, supervised, and I think it should stay that way.
Okay, thank you. Anything else, Ms. Parr?
Yes, Your Honor. I really wish you grant my motion, because nothing is a lie on that motion. Everything is based on the truth. That the court does misunderstand this all year long.
Well, the court notes that Ms. Parr has filed multiple motions in the past, and her motion now simply reiterates the same allegations that she's previously repeatedly asserted. The motion basically...
So where does this case leave us? The mother made impassioned pleas, citing financial hardship and serious allegations. The father stood firm, pointing to existing custody and support orders. And the judge? He held the line, denying her motions because they failed to meet the legal threshold of new, credible evidence. In family court, emotion and history weigh heavily, but the law demands structure, consolidation of cases, enforceable orders, and the standard of changed circumstances. Whether you side with the mother's desperate struggle or the father's insistence on stability, one truth emerges. These cases show how family law can feel less like justice and more like survival. If you found this breakdown as gripping as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Your engagement helps us bring more of these stories to light.